Welcome to the show. Thank God it's Friday. So today is Judge Elizabeth Mogen, Melissa Mogen, Judge Melissa Mogen. And don't, if I'm not being antisocial, but I'll be switching between while I'm presenting from you to you in the chat. So it's not like I'm being antisocial. I have to watch ads because ads with music get your channel copyright struck. So here we go with Judge Melissa Mogen.
In the matter 21 CV 129, Taylor Excavating LLC versus Tony DiNardo and Scott Vogel and third party Eva Development Inc. Appearances are we do have appearing in person. We have Michael Taylor for Taylor Excavating. We have counsel Joel Porter for the Taylor Excavating. We have Ms. DiNardo as well as Mr. Vogel in person without counsel. We have Eva Development through David McGee. Mr. McGee and Mr. Porter appear by video conferencing. We're set today in this matter on a few reasons. One, a motion for reconsideration or alternate motion leave to amend. Ms. DiNardo and Mr. Vogel, you are representing yourself, is that correct?
Correct.
Yes.
And your previous counsel filed, I believe, on September 25th, a motion for reconsideration and relief, or in the alternative, motion for leave to amend. And is that what you're going to argue and stand by here today? Or why are you here and what are you asking of the court?
We are asking of the court, Your Honor, in the memorandum that you provided, stated that you would allow discussion and to, I apologize, it's right here. It says here that the court will allow the parties to present their positions on this matter. And this was filed on September 29th. And also the motion and the notice of motion and motion for sanctions.
So what I'm hearing from you, well, because yes, I now pulled up my memorandum. I probably have it in my written form in my documents right here. But in my memorandum, the court was fully directing your counsel to the errors in his brief or his inaccuracies in his brief, actually, as it related to the getting the court approval to be able to amend pleadings. And that means to add a third party defendant as well as to amend the answer and the affirmative defenses that you had in that case. Because your side, Ms. DiNardo and Mr. Vogel, you have never received the court's approval or authority to do such. And so essentially that's why we're here, or I'm going to allow you to be heard on that issue. And now I'm hearing that you would also like the court to hear again with regards to the sanctions? Or was that just a misspeak?
I think part of it, and the motion for reconsideration of your decision.
Oh,
or of the court's decision.
Of what decision?
Of, excuse me, let's see here. I do have a statement regarding the discussion from our attorney from back in April, and then motion for reconsideration regarding the court's decision to not grant further sanctions against the plaintiff.
That has already been decided because the court did its order. You asked for reconsideration. The court then had its other order, and your next step would be the Court of Appeals.
Right. And that's where I thought there were two filings here, so my apologies. Motion for reconsideration.
Your time.
So on September 26th, he filed motion for reconsideration and relief, or in the alternate, a motion for leave to amend.
Correct. And that has nothing to do with the sanctions because sanctions are done and decided and they're over.
Okay.
All right. That is a Court of Appeals matter now, if that is where you wish to go with that. But he was asking, and I pulled up his electronic document right now, it's reconsideration or relief in the correct solution under the circumstances. He was asking for the court to reconsider its decision as it related to not allowing or taking into account your amended answer and amended affirmative defenses.
Okay.
Okay. So that's what he was asking the court to reconsider, because in the court's order dated September 22nd, 2025, that is where the court then pointed completely squarely out to all of the parties that at no time did the court ever have any request to amend your answer, which was filed years ago, years prior to the amended answer, and to amend the answer or to add additional affirmative defenses or counterclaims. Because as my September 22nd, 2025 order states that the defendant's amended answer, affirmative defenses, and counterclaims is not received by this court and is untimely and is stricken from the record in this matter. And so the reconsideration is asking the court to reconsider that decision. And is that what you're going to argue here today?
Yes.
Yes.
Okay.
Yeah. Yes.
All right. And so you can understand, I know you're lay people, you're not attorneys. Hopefully your previous counsel went over with you. Second thing is he's saying, or if the court is not going to reconsider that decision right there and is going to continue to have it struck, he was motioning the court to allow you to be heard on whether or not the court would allow you now and permit you now to amend your answer and to file more affirmative defenses and additional counterclaims.
Thank you.
So
thank you for explaining that a little bit more.
Want to make sure you understand clearly because you're here to do the arguing. I can't assist you legally. You're here represented by yourself. I cannot assist you other than things such as explaining things so you can understand what it means legally. There may be objections here. You may have to object here too. I'm not exactly entirely sure how today's hearing is going to go. Okay?
Okay.
All right. So that's what you're going to do then, is ask the court to either reconsider or to argue to allow you to refile the second or the amended answers, etc. Okay. Now, Mr. Porter, I'm going to turn to you with regards to your position for today and the basics of what you're going to argue before we determine how we're going to proceed in the hearing.
Your Honor, I would oppose the defendant, third-party plaintiff's motion to reconsider or for leave to amend. The basis would be that there's no excusable neglect after this. We did have the assistance of counsel throughout this matter up until now. And jumping beyond that, I do not feel the extraordinary circumstances to change your mind in the interest of the justice have been met. Again, they've had counsel all the way up until now, and there's no excuse.
All right.
The nutshell version.
Excuse me, what?
That's the nutshell version.
Yep, and that's the nutshell version. And so other than that, in your opposition to their motion, There was nothing specific that you were arguing to the court on behalf of Taylor Excavating.
Nothing other than, I believe the law is that this should not be granted unless there's excusable neglect, or that there's such extraordinary circumstances that the interest of justice would require it.
All right. All right. Okay. All right. Thank you. So I'm going to turn now to, first, I'm just going to have the parties here, just so we all are under oath and we're all saying things that are accurate and true and under force of contempt, or not force, but if there are lies, etc. Can I please have all of you stand up, raise your right hands, and be sworn in?
Do you affirm that the testimony you're about to provide in this matter shall be the truth, the whole truth, and nothing but the truth?
Yes.
All right, you may be seated. So, Ms. DiNardo and Mr. Vogel, you're both here together and you are both defendants, third-party plaintiffs. You both will have an ability to argue or to say something to the court, but I need one of you at a time, okay? So don't like talk over each other, and don't try and talk. If Mr. Vogel is making an argument, please refrain from trying to jump in, Ms. DiNardo. You will get your opportunity just the same. You have the ability to call witnesses. That means you can call people and you can ask them questions. You can ask each other questions, essentially, or just make your arguments and statements. You are under oath. You cannot perjure yourself, or you could be found in contempt with sanctions down the road. All right, so that's where we are. So why don't we start with you, Mr. Vogel?
Well, the reason that we're here is because, well, what I understand is that this took so long to get into place, and we did proceed with a whole bunch of other dates and everything with our other with the sanctions, not sanctions, but our attorney. I don't even know what to say. You might as well.
Well, okay.
You know, what I'm getting at is I just don't. We are at the point where we didn't have discovery from Taylor. We didn't get any of that from him, and it took how many meetings that we've had, and wondering why it wasn't being done. How come it hasn't been done? And then we left it back to you, and then it came back to we came back again, and it still hasn't been done. I can't remember the dates or whatever. We got it all here, but that we're at the but then all of a sudden at the third hour, then this came in to where we didn't, obviously we're not lawyers, but we didn't know that this was something that could come back at us. But we're at the point where they didn't have discovery. They didn't for months. We gave them another chance to have discovery. Nothing came back. Talked to them again, still didn't get anything. We did sanctions, and then all of a sudden now we did something wrong at the beginning of this, way years ago.
Okay, Ms. DiNardo.
So right now there is a situation that we're dealing with the previous attorney. The only reason why we don't have Attorney Hetfield today is because of where we're at, and he set us up to be able to move forward so we didn't miss out if we needed to go to the Supreme Court.
Oh, Court of Appeals.
Or Court of Appeals, whatever, sorry, my apologies. And it was a decision that we all made together, that there's so much money that we have wasted with previous attorneys that didn't support us. And when the minute that we retained him, that's when he had actually filed for the telephone conference. And during that telephone conference, I mean, I have the description of the scheduling conference stating because Attorney Benson was on that call as well as himself. and they were very clear on what it was and the concerns, and if Attorney Benson had any objections to it, which he had none. The clerk asked how long our attorney would need, and she approved the extension, and the extension was added to
She
the.
can't approve it. She
Okay.
can't do anything. She has no authority, only I do. She's a clerk, or she's not the clerk. She's my assistant.
Yeah.
All she does is dates. That's it. All the arguments, all the things that they wanted to say, boo hoo hoo, cry, 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 none of it matters to her. She's like, whatever, doesn't matter. Okay, you want what day, or how long do you want? The issue that falls, it's your attorney's fault. Your attorney didn't do what he needed to do and filed that in writing right away. Statute.
What I'm sorry, Your Honor. What did he need to file in writing?
You said you used to be
Yeah.
very
Wear many
clear
hats.
with
Yeah.
statutes. I put that statute in my decision. I'm pretty sure it must be in writing.
Okay, that makes sense.
It's very clear in the statute that any decision or any agreement and stipulation between the parties, they can agree all they want all day long. But unless it's put into writing, or I say, you know what? Okay, we're saying it in open court. You're asking this right now. Bing, bang, boom. And so be it. Either I get to say, or so be it, or it needed to be done by your attorney in writing and sent to Mr. Benson, and Mr. Benson needed to sign it with his client and get it back to, or get it filed with the court, either to your attorney or to the court. None of that happened. None of it. If they wanted to argue or cry or complain or say whatever they want to say to my assistant, it goes through the ears because she is not a part of this. She's a date person. She gets the date. That's what a status or a scheduling conference is. What dates do you need? What are you doing? Whatever negotiation they had on that between themselves, it means zip, nothing unless it's in writing. Okay?
Okay. Well, this one was a new one to me, so thank you for clarifying that. So that gives you a little bit of a history of our previous attorneys anyways. And I think that where the confusion lies then is, so if we were to go back to that February hearing though, Attorney Benson stated that him and his client have not communicated and he has not heard back from him.
I think. So I guess, is she on the right track with bringing up what we're bringing up, or do we?
Well, this is your case and you can argue it however you wish to argue it. I can't say,
Right.
oh, you're leaning more this way or you need to push harder this way.
Is there something that
I guess if we didn't file the paperwork, right?
However, so that wasn't mentioned about the paperwork until September or October, excuse me.
Well, I'm going to tell you, he didn't want to say, oopsie doopsie doopsie.
Mm-hmm.
Look, guess what I failed to do? Okay, guess what I didn't do on your behalf that I was legally obligated to do to ensure that I covered you.
Okay.
That's what happened.
So then,
I think where you're going at is so, but I think what's important is that February 20th hearing, because at that moment you were ready to dismiss. You gave us an opportunity to dismiss the hearing in its full because Taylor hadn't provided any discovery. He's not extensions were continuing and
Well, that was his attorney's problem. Your attorney, you had 4 attorneys. None of them did anything that they needed to do for you, right? He had 1 attorney. His attorney didn't do anything that he needed to do for him, right? So you both had attorneys that weren't doing what they needed to do, to the detriment of both of you, okay? Because you both are hurting now, and you both will unfortunately be hurt, but you have the other ways to go around this. You have Yeah, you could file with Court of Appeals. You can do that, right? But then there's that malpractice, right? Which I'm guessing that you did with one or some of the attorneys, and it
That's
sounds
all
like
in the process,
yeah,
yes.
it sounds like that's what you're doing. And I'm going to tell you, if you have malpractice claims, though, you don't get a double windfall. You're not going to get like double from this or claim from this.
Right.
That's to cover whatever they failed to do, and they failed to protect you in this process, and what you lost in the case because of their failure to do what they should have done.
Right, and we understand that 100%. However, I know for a fact that, you know, something like this, I mean, we're the defendants and we were the plaintiffs in other cases, and we made sure that we stood strong. We questioned our attorneys why they didn't do this, why they're not doing that, and we didn't let it sit for 4 years. We continued to.
And again, then I say it's your fault too, because you may have had the label entitled defendants, but you had what's called counterclaims. Counterclaims means you kind of step into the footing of a plaintiff, because you're saying, I am now suing you and saying you owe me for this. It's not what it is, but it's kind of like that, because you're saying I have claims against you too. So you should have been just as adamant and just as on the heels of your attorney in this case, just as you were those other 3 or 4 cases where you were the plaintiff, because you had your counterclaims and you were saying, well, Taylor Excavating, they owe me, they owe us actually. We don't owe you. You owe us because of X, Y, and Z. You didn't do it right. You didn't do this, and you failed to do this. Now we have to build this huge other driveway. We have to do it, and it's not comporting or complying with ordinances, or all of those arguments that you made in your answer, and then had those counterclaims. You essentially are a plaintiff, even though you're defending yourself. So you should have done all of the same things you did when you were titled plaintiff. Okay?
Yeah.
So the fact that you stepped aside or you didn't aggressively do the same actions because you thought you were a defendant, that's not an excuse.
Oh, it's not about being a defendant or plaintiff or making an excuse. It's just, I was just simply stating that back when we had the attorneys and why we just continue to question. And the reason that it took so long to find another attorney is because there were so many conflict of interests where we couldn't find an attorney. So now we're just now learning that our attorney failed us, but it's only been since it's been a short time.
Well, I want to say
for
your
him.
latest attorney may have failed. May have, and I don't know. I don't get to make that determination. Right. That is up for the other people who are going to look at that matter. But your latest attorney may have, but it sounds like your other attorneys may have, or one or more that you believe. It's for you and for what you may feel or you may know, and your claims against them. Okay, so you may continue.
I think the biggest issue here is the fact that we haven't received the discovery documents. We haven't.
You did, though. You actually did receive them.
Not until just recently. Recently. So I mean, I think by the May 19th hearing, or the September, it was like 256 days later in some sense, and we still hadn't received them. And Taylor had stated that he's known about this since February, and he mentioned it while he was
on the bench.
At the last hearing that we had. He took the stand and stated that he has known about it since February. He's known about it all being late. He's had an opportunity.
He's been sanctioned.
$1,600. And
I don't know where you're getting $1,600.
I think I have a receipt from our attorney. That he provided.
And by the way, that my phone just rang. It's muted. It was muted. I don't know. what craziness is with the silly phones, but it was
Technology.
muted and it rang. Weird.
Whatever he was sanctioned back in February, I apologize. I keep on referencing the February hearing because at that point, there was an opportunity to dismiss it fully. And the only reason that it was not dismissed was because we were waiting for discovery responses for our counterclaim. And
Again,
that,
counterclaims that
but at that point, nothing, no, and I get it, I understand. But at that point, it wasn't brought up or mentioned and so then you extended it to, you extended it by another week. Should I actually have it?
and I know the succession of the dates and times.
Yeah.
Okay,
Not only have I went over it in multiple decisions and orders, but yes, I'm very clear in the timeline. So you don't have to be as clear because trust, I know those dates.
he's just like, I don't remember the date, so it's more than.
That's what so that's where my thought is at one point that this was getting to where it was going to be dismissed.
No. It was never going to be dismissed. Could have been an option, but I stated at the hearing that is a possibility. That is a severe and harsh punishment when at that time it wasn't as exactly clear if it was strictly attorney's negligence or party and attorney's negligence. But if the court would have dismissed and it would not have been the party's negligence, that is an extreme and harsh sanction.
Yeah, but it was also mentioned that in that too, that, you gave the option to our lawyer at that time, what would you like to see done here? If I'm not mistaken.
It's right here.
Did you read it?
It says.
I always ask, what are you looking for? What do you want? What are you asking of the court? I always ask that.
Okay.
It's not because I was saying, I believe everything you're saying and I'm doing all of this.
Okay.
What do you want me to do?
Right.
No, I always say, okay, just like I asked all of the parties, what would you like me to know? What are you seeking? What are you asking of the court here today?
But but at that point, that's when we held off. Why shouldn't I just dismiss this case right now?
You want me to be honest? I was saying it because of the attorney.
Yeah.
Because if it was the attorneys, I was saying it to the attorneys because, again, you all are lay people. You don't understand the sanctions and the harshness of sanctions. And when I was asking that, I believe was directed at Mr. Benson. Why shouldn't I just dismiss it right now? Why shouldn't I do that? It was directed at Mr. Benson to put him in the hot seat.
Okay.
You did state in there, because our attorney at the time, that we do have counterclaims against plaintiff as well as would be remaining. Unfortunately, we can't move forward without anything on those just due to lack of discovery. And then he said, that's where you did say, because he's like, if the court is entertaining dismissing the case, I'd also request the court would grant judgment in our favor on our counterclaims as well at that point. That's when you said that is a harsh, as you know, that is a harsh sanction for the court to provide. So I think where he's going and where both of us are going is at that point, there was an opportunity to possibly dismiss this. And I get it that you're just saying any reason why I shouldn't dismiss this, but you also stated that all deadlines must be complied with in the scheduling order. And you're going to enforce my scheduling order. And the next hearing, that's when you stated that you would like, he asked for February 28th or March.
Yep, I gave a date.
You gave a date.
He failed to meet that.
And you failed to meet that date. And then after that date, that's when our attorney filed another motion. And that hearing on May 19th is when Taylor appeared at the hearing for the first time since.
I think he was at the February hearing.
No, I was there. He wasn't there. Just
Video.
no.
I can't recall off the top of my head, though. I know that there was one, but I did state in my decision when he did appear and when he did have full knowledge of what was going on in the case. And it
Right.
could have been that March hearing.
I think when he took the stand at the last hearing, he stated that he's known about it since February. And prior to that, he's failed to make any of his discovery, and it's affected us in many different ways. And that includes, I get the counterclaim piece of it, but it just includes all of our future with, our house. We can't, if we were to sell, we have to disclose the mound system. And we can't, you know what, right or wrong, that part doesn't even matter. There's just so many areas that we are being left with because he didn't provide us with the discovery and interrogatory statements. He's 100% violated all of the statutes to help us get to our next steps. We've done everything that's been asked of us.
Well, they're now.
Okay, well, that's where we need to
Again, you guys
address
can't
the
talk back
attorney.
and forth.
Oh, yeah. So that facts are facts. He just did not provide any of the discovery, and he had an opportunity to provide you with a letter, a written statement that states.
Not Mr. Taylor.
Yes.
Nope, not Mr. Taylor. That was directed to his attorney. Why his attorney did not do it. That was not directed at Mr. Taylor.
Because
Did the attorney?
What's it? Oh, we can't talk. Ask.
Did the attorney give his explanation?
Well, if it's not in your file, then you don't have it. But here's the thing, he did not. And that's exactly then why it's went the route it has. And at that point in time, it became clear that Mr. Taylor was not fully aware of all that was going on in his case, just like you two were not fully aware of all that was going on and not going on in your case. You both have had things going on and not going on that should have been going on that neither of you, all three of you, were not aware of. That became very apparent to this court, very apparent to this court.
I guess the only other piece, I just feel like, we are responsible for, we've got a letter of engagement that we have with our attorneys, and, it's up to us to enforce them, and we have enforced them, and which is why we've got claims with Office of Lawyer Regulation, Wisconsin Lawyer Fund. We've got mediation set, we are, and with all of them, not just one.
No, and I understand that, and I'm gonna let you know, let you all know, I get the predicament that all three of you are in. All three of you, 1, 2, 3. There have been multiple errors done by both sides. Neither side, and that's why I was so harsh in my memorandum to your last attorney. He tried to tell the court that the court didn't know what the court had said and what the court had done, and that the court does not understand the law. I do. I very clearly do. I understand my cases very well.
Yeah.
And so I wanted to ensure that he knew. And that's why it was like, boom, I shot it off right away. I know my cases. I know them. I know my dates. I know my facts. But the thing is like this case has had nothing go on for, I think, 3 years, neither side. And then both sides asked the court, hey, can we have more time? Because we didn't listen to you the first time. We didn't follow your direction the first time. I'm going to tell you, I could have dismissed this case outright so many times for both sides. And I did not, because I thought, okay, let's get this going. But now we're going on 4 years and nothing has happened. So, all right. So, Mr. Porter, your arguments?
Yes, Your Honor, and if this had been a question and answer format by counsel, I would have been objecting throughout it, but I'll just make one objection now. Everything they've said relates to sanctions about not getting discovery and so on, and that's not why we're here today. We're here for their motion for leave to amend or leave for permission to file an amended answer and counterclaim. Also then, because their counsel did not comply with your court's original scheduling order, that amended answer and counterclaim were years late. As an aside then, all that discovery related to the amended answer and counterclaim, which your court has stricken. So I don't see that there's any reason for any renewed sanctions if that's what they're now requesting.
I don't believe they are. I think they misunderstood what all the steps were and where we were. That's my understanding.
Okay. But the bottom line is that their counsel, whichever one of the counsel did not file that in a timely manner and did not request leave to file it. Again, from their testimony, there's been no excusable neglect. It's very seldom that the court grants excusable neglect for the errors of counsel.
And I'm just going to stop you right now, just because they're not represented, and I'm just going to point to them because you have a pen and paper. There are some key words you probably should be taking down of what he's saying and what he's arguing. I'm not going to tell you what they mean or anything like that. I'm just pointing out he's making a good argument about the law and what the law is and what the court has to look at. So key words like that you might want to jot down and look at after. Okay? All right, Mr. Porter, sorry.
Yes, and for the defendant third-party plaintiff's benefit, I think some of those keywords are excusable neglect and interest of justice. And if they Google those, they'll find them in the statutes and they can do their own research beyond that. But it's my position that nothing they have said shows excusable neglect. Nothing they have said shows that there are extraordinary circumstances here such that the judge should give them leave to do those things in the interest of justice. And Your Honor, it's too smart for me to sit here and bore you with more, and I don't think any additional testimony is necessary. I think everything's in the record.
All right, thank you. I appreciate that. Mr. Porter did state exactly what case law does state for the court, and perhaps it is identified in the statutes as well. And that's why I just wanted to make sure that you understood what he was arguing and saying. Keywords that pop out to me, interest of justice, is something that the court has to look at. I'm going to tell you, as of right now, in the interest of justice for both sides, quite honestly, in the interest of justice for both sides, I've heard both sides and their arguments, and I have a really good understanding of this case and what happened, what didn't happen, what should have happened, and what didn't happen, etc. In the interest of justice, I'm staying on a decision as it relates to these matters because I'm ordering mediation one more time. Okay? So I'm going to order mediation one more time. If I were, and you wanted me to make a decision here today on the bench, or even if you wanted me to do a written one, I do it far more thoroughly. But if you want me to make a decision here on the bench, I don't think either side will be happy. Either side will feel like justice was served. Both sides will probably feel forlorn. So I am staying on my decision as it relates to this matter, and I'm going to order mediation.
Going into mediation, and once again, part of the issue when we went into mediation previously, the attorneys were not, Attorney Benson was not given the information from our previous attorney of everything that we had learned
Well, here's the deal. You all know where we are right here today. You know that you may not have any counterclaims. You may not have any additional affirmative defenses. You may be where you are at the very beginning. And you know, and Mr. Taylor and Mr. Porter knows where Mr. Taylor sits from the sanctions. So you both know that you're not at the best of all best places that you both could be. And Mr. McGee, the parties know where EVA Developments sit, and you sit from that decision, because in that decision, I was very clear at what could still remain outside of with your arguments or your claims against EVA Development. EVA Development, we went through a very thorough summary judgment hearing with EVA Development. Therefore, the court is not striking the third-party complaint. That is remaining.
Okay.
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 Because that should have been something raised by EVA Development at the time and said, hey, judge, this is where we are. That's why we shouldn't even be here. That would have been wham, bam, done. But it went to a full hearing. It went to a full decision. So that they waived the right for that defense. Okay.
Okay.
All right. So, but you know that it's very clear. So read my decisions and you'll see, because in my decision, as it relates to the driveway anyway, your arguments where it doesn't, it's not compliant with Burnett County ordinance, blah, 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 but it is, because I have that documentation and that evidence from the county. Okay. So read and you'll see where EVA stands. You'll see where you stand in those arguments. And then you know where you could possibly stand at here or here, depending. And you have my last decision, so you have an idea of what could happen, just as Taylor Excavating and Mr. Porter do. Okay?
Okay.
So I'm ordering all sides to be very open and trying to be willing to work in mediation. Okay?
Okay.
All right. So can we do January 14th?
Okay.
My wife of 53 years and I are going to be in Mexico, Your Honor.
Well, I don't.
And if my cell phone works, I could do it that way.
Nope, I'm not. I don't interrupt vacations. That's one thing I don't do. Unless this was a homicide case or something.
Watch what salt does to blood.
Well, if I'm hearing from the state that from July 2022 until February 2025, had no idea that the victim had a TBI and had an ability to recall certain facts and would not make a good witness, and they can't prove their case. And it's been going on for this long and using all of these resources. All right, so I do have all necessary parties. We will go on and can court hear me?
We can, Your Honor. Thank you.
Thank you. Thank you so much. We will go on the record in the matter 22 CF 87, 22 CF 114, 22 CM 52. State of Wisconsin versus Nicholas Contreras. The state appears through Assistant District Attorney Christian Ness in Washburn County Courthouse. We have Adam Welch appearing by video conferencing with approval of the court. We also have Mr. Contreras appearing by video with approval. This court appears in Burnett County Courthouse by Zoom to Washburn County. We're set here today for the final pretrial in all of these cases. I have received and reviewed the state's request to dismiss 22 CF 87 along with 22 CM 52. I've reviewed the basis for that request in the fact that the court or the state believes that after thorough review and preparation for the trial, the state believes that they lack further merit, and they could not be able to prove to a jury beyond reasonable doubt and prove guilt beyond reasonable doubt in these two matters. First, I'm going to ask the state for a more thorough statement as to those cases, and then I'm going to ask the state if that is applicable to 22 CF 114, which is a felony bail jump. The basis for that felony bail jump is being on the felony bond in 22 CF 87 and being pulled over in Burnett County and operating with after revocation. So therefore, Mr. Contreras was driving without having a valid operating privilege. So Mr. Ness, first off, does the request to dismiss include 22 CF 114?
No, Your Honor. I submitted a request for the two that are scheduled for final pretrials today. I think that the factual basis and the reason for the dismissal is separate from the bail jumping case.
So we're continuing with the jury trial for this felony bond?
I don't believe it has been set for trial yet.
Oh, I'm proceeding with this trial on that date and time.
Okay. My understanding is it hasn't been set for trial. I'm fine.
Oh, no, all of mine are backed up. If one resolves, then it goes to the other one, and then it goes to the other one. So this court will proceed with trial on that felony bond case unless the state is telling me it's dismissing it or it's resolved, and that's here today. Because we have the jury trial set and scheduled already in these cases, and all the time, that is this court's policy. It is always fallback. If one resolves, then we move on to the next case for that jury. And if that was resolved, we move on to the next case. So in this court's, in looking at this case and in these cases, we are set to go to trial then on March 25th for a felony bond jump, unless the state tells me here today that it is either dismissing the matter or the matter has resolved.
Understood, Your Honor. I don't object to that. The only reason I did not think that was because the calendaring, it has been set for a status conference today and for that date. I don't put it on my calendar that way. I'm not the one who sets it on my calendar, but that's how I work. So if you need time to talk to Mr. Welch to see if it can resolve, we can have a later hearing today, since this is our final pretrial, and you can inform the court on whether or not we're going to proceed. But at this time, I am not dismissing any matters until I hear what's going on with 22 CF 114. Well, understood, Your Honor. I don't think that further discussion is necessary. I think that the parties have thoroughly discussed possible resolution. I just don't think that there is a resolution at this time. I could talk more thoroughly about 22 CF 87 and 22 CM 52. In each of those cases, it's the same victim. The victim in both of those instances has requested that the cases be dismissed and has made statements to my office to me, including that because of a traumatic brain injury, she has no memory of any of the incidents that are the factual basis for either of the crimes, and that she would not be able to testify to any of the facts within them. And so I believe that constitutes essential facts under both of the cases. And so without that testimony, I don't believe that I can proceed.
When did she have this traumatic brain injury?
I think she's had this for years, Your Honor.
She's had this for years, and prior to, are we talking prior to these incidents occurring?
Correct.
And from 2022, from July 27th, 2022, and from July 28th, 2022, up to February 27th, 2025, I'm hearing that the state in no way, shape, or form ever talked to the victim in any way prior to those dates and times, which were going on 3 years, 2.5 years, never from that time spoke to the victim about her TBI and whether or not she would recall any of the incidents and as they occurred or any of the facts. That's what I'm hearing. So I'm hearing that we've had a tremendous waste of resources. Is that what I'm hearing, Mr. Ness?
If you're sitting around Googling how to make money on the internet and you're
No, Your Honor.
That's what I'm hearing.
Your Honor, I've spoken to this victim previously. This was a revelation later on in the case. She has, frankly, Your Honor, I'm not certain that I find her statement regarding her traumatic brain injury to be entirely credible. But if an individual is making that statement to me and is indicating that they would not testify to the essential facts of the case, I don't believe that I can call her and expect to prove a case beyond a reasonable doubt.
You still have a duty to subpoena her and call her as a witness, even if she is a hostile witness, and you have the ability to at least try and prove the case, because we are talking, there may be allegations against her. There's a take and drive without consent. There's disorderly conduct. Those are things that you may not need the victim to have full ability to recall and to testify about, correct?
That may be true, Your Honor. I've discussed this with the district attorney. I think it becomes a delicate issue because the public policy consideration is not to treat victims of crimes as though they are criminals. And I think that the forcing a hostile victim to testify and putting the force of the state on them through a subpoena, I think it violates that public policy consideration of my office.
So from July 2022 up until just recently, and I'm going to say, I'll even give you a little bit of credit, last week, up until then, victim was, yep, I'm ready to go. I recall all of these things. Let's go. And then last week, or a couple, I'll even give you 2 weeks, she was like, oops, nope, I don't recall. That's how it went down?
No, Your Honor. This happened previously. It has been discussed with, there was a request. I made a statement on the record regarding a witness changing her story. The defense attorney at the time met with me in my office with an investigator. I disclosed what had happened and what was being discussed. There was a proposal for a global resolution as to all cases, and I believed that it was possible to resolve these matters globally on a misdemeanor basis until recently.
And Mr. Welch, there is what I'm hearing, at least from Mr. Ness, and I'm going to not take into account the two serious matters, but to the felony bail jump, there's absolutely no way that this matter is going to be able to resolve and we're going to trial.
It certainly could resolve if Mr. Ness wants to, but there's not a resolution right now.
Because I can give you the day. Because
I
today was my day.
If Mr. Ness wants to talk about it further, I'm happy to talk. If he tells the court that there's no point in further discussions, then we'll have a trial.
Mr. Ness?
Well, Your Honor, my understanding is that the proposal from defense is to plead to misdemeanor bail.
Your Honor, I'm sorry.
Fine.
Sir,
well, no, and Mr. Welch, I'm going to ask you anyway. I have the right to ask what the offer is. I have the right to reject any offer in the public interest. And if he's saying it's a felony bail and your offer was to amend to a misdemeanor bail, boom, there.
Understood, Your Honor. I just don't want to create a situation where the court's pressuring either side. So
I'm not pressuring any side.
I didn't say the court was. I just was trying to head off that possibility, but I apologize.
My pressure to both sides are we going to continue to use government resources since 2022 until 2025, and then go forward with a trial with a felony bail, which I am fully prepared to do. I have 2 days set aside on my calendar, 2 full days set aside on my calendar, which is a lot because I am a very busy court. So I have 2 days on my calendar to have this jury trial. So I just need to know if there's a potential ability to resolve or if we are proceeding in a jury trial fashion.
I think I've made a proposal to the state, and if the state wants to discuss it further, I'm happy to discuss. If the state is just telling us that there's no reason to discuss further, then I'm prepared to go to trial as well.
I don't think
Ness.
that it's likely to resolve, Your Honor. I don't think that there's a point in further discussion.
All right, then we're going to jury on March 25th for a felony bail bond violation case. Everybody's ready to go?
Your
So
Honor,
that means I need everything filed. Today was the deadline, but I'll give you a week to get everything filed. I'll extend it to a week since there was misunderstanding as to how this court functions. 1 week. All discovery, all witness lists, all motions in limine, all necessary documents needed for the trial. And we will see you on March 25th. And I'm going to tell you, this is my drop dead date. That means I will not accept any agreement passed today. We are done with negotiations. We're done with resolutions. That means this trial will proceed. The only way it will not proceed as a trial is if Mr. Contreras pleads guilty to the charge. Whatever the resolution is, that's for argument's sake and for whatever can be negotiated. But with regards to that, either he pleads to the charge or the state dismisses it. But we're going to trial March 25th on a felony bond violation. Because we all had that day set aside. Court has it set aside. I have it set aside. Mr. Contreras has it set aside. And it is in the public interest to keep this matter moving. It is a 2022 case. We are now in February 27, 2025. Do we have any questions?
so Your Honor, is the court signing the orders then on the 2 other cases?
Well, if I'm hearing from the state that they, from July 2022 until February 2025, had no idea that the victim had a TBI and had an ability to recall certain facts and would not make a good witness, and they can't prove their case. And it's been going on for this long and using all of these resources. I guess it's kind of a quandary for the court. I can't force a trial upon a victim who would be put through the ringer, and quite honestly, a defendant and the public justice system. Resources have already been wasted. So I will sign those 2 dismissals, and I will see you for jury trial for the felony bond jump violation. And with regards to that case, what I'm going to do is I have cash on the other matters. I'm transferring that to 22 CF 114. I'm making sure that the bond is applicable to 22 CF 114. It is. It looks like it's filed in 22 CF 87, and it says the bond to cover all of the cases, same conditions as previous bond. So same bond, same conditions, same cash. We will see you March 25th. Be ready to go.
Will do. Thank you.
Thank you.
I found out there was a gap in our financial.
We will go on the record in the matter 25 CF22, State of Wisconsin versus Michael Den. The state appears through District Attorney Kevin Schmidt in person. Mr. Den appears in person in custody with counsel Glenn Keene. We're set today in this matter for the sentencing portion of this case. Mr. Den pled guilty to count 5, possession with intent, methamphetamine greater than 10 grams but less than 50 grams. A class D felony with having 4 other counts: manufacturing, delivering amphetamine less than 3 grams, possession with intent, methamphetamine greater than 50 grams, maintaining a drug trafficking place, and possession of drug paraphernalia as dismissed and read in. The court ordered a pre-sentence investigation report. the court has reviewed this report. I have notes, but I do not necessarily see that anything jumped out to me as needing to be changed as materially affecting the information to the court. Mr. Schmidt, did you receive and review the pre-sentence investigation report?
I did. I reviewed it. I have no corrections.
All right. Okay. Mr. Keen, did you go over that report with Mr. Dunn?
Yes, Your Honor. The only thing I would attempt to correct on page 7, it does talk about that he was revoked twice. I would note that later on that page, it talks about those being, 17 days of revocation. So I'd just point out it's a relatively short revocation versus revoke, go to prison. But other than that,
Okay.
nothing that we won't explain when we get to it.
All right. Thank you. And Mr. Keen, when I walked into the courtroom, I believe it is Mr. Dunn's daughter that was sitting up there and she had papers. Is she going to be providing a character statement today?
Your Honor, she provided a letter. She may end up making up her mind if she wishes to speak at the time, because I know she said it's hard for her.
All right. Well, then she has to make up her mind now, because I usually have the character references, witnesses, as well as the victims make their statement first to allow both counsel the opportunity to provide input or respond if there was something that needed to be addressed.
Okay. Do you want to talk or do you want to just use your letter?
All right.
Okay.
So you can come up here and have a seat at that black table over there. And you can state your full name if you wish, or I don't care if you want to use initials, that's fine too. If you're going to read your letter, which is totally appropriate and fine, please read it slowly so that the court reporter can take everything down. And I know that this is probably an emotional process for you, seeing your dad this way. So if you are affected by emotion, just take time, take some breath, and then go on, okay?
So state my name first.
Yes.
Jamie Den.
Okay, and it's Jamie, J-A-I-M-E.
J-A-M-I-E.
J-A-M, oh, so just the normal spelling, Jamie.
Yep.
Okay, all right. You may begin.
My name is Jamie Den. I am the daughter of Michael Den. I'm writing to you regarding the sentence of my father. I have a daughter who is 14 and a son who is 9. They haven't had a father figure but my father to look up to. My kids haven't listened to me ever, but they do listen to him. 2 years ago, I had a lot of problems with my son, where he was kicked out of summer school and off the bus. After spending all summer with him, he was a totally different kid that listens in school. I have had the privilege of growing up under my father's guidance and support, and I have witnessed firsthand the positive impact he has had on our family and community. My father has always been a source of strength and inspiration for me, and his dedication to our well-being has shaped me into the person I am today. I understand the seriousness of the situation, and I want to share some insights into my father's character and the positive impact he has had on our family and community. Michael Den has always been there for me or anyone that has ever asked, no matter what. Anyone that has ever asked anything from him, he has always gone out of his way to help with whatever they needed. Like an elderly woman, that husband left and went to another state, didn't have food or running water. My father went out of his way to get her water and bring her to town to make sure she had everything she needed. Even got a vehicle running for her so she had transport to go to town. Last winter, our neighbor would have froze to death because he got sick and couldn't cut wood to put in his wood stove. He ended up calling my father and asking for help. Not only did my father bring him wood, but he split it and stacked it, so the guy didn't have to do anything. Every morning, my father would go there and fill it up for him. I am sure your mind is already made up, but I have lived with my mother my whole life. When I was around my father, all he ever did was work. I hated the fact that he never did anything fun. It was always work. My older brother, for example, all he does is work too. He is getting old and his grandchildren need him. Not only for grandpa, but to be on the sidelines for their sport events, cheering them on. Thank you for taking the time to hear my letter and consider my opinion. I hope that my words will help you in making a fair and just decision.
Thank you, Ms. Den. And so you can understand, I don't make a decision. I need to hear from both of the attorneys, and I need to hear from Mr. Den and character references, as well as any victims if there are any involved.
Navy SEALs are banned from doing crunches and sit-ups.
So I'm just letting you know that ahead of time. All right, argument and sentencing recommendation, Mr. Schmidt.
Thank you, Judge. I'm going to be arguing for the upper end of what DOC quoted in this one, which is 15 years initial confinement, 5 years extended supervision. I think that this is the correct sentence. I think the main purposes of sentencing the court should be looking at today should be incapacitation, specific deterrence, and protection of the community. I think this is the sentence that does not unduly depreciate the seriousness of the offense and is proportional to the sentences he's gotten in the past for similar behavior in the criminal history. This is a case where a confidential informant did a controlled buy while being surveilled by Deputy Bailey Mogen. He purchased a small amount of methamphetamine from Mr. Den. You can hear them in the recording do this. Police got a search warrant. While staging for it, Mr. Den pulled into the driveway of the same property. Michael Den was arrested in his vehicle. In the vehicle, they found a large amount of methamphetamine. In another vehicle on the property, they found more large amounts of methamphetamine. To give you an idea of the property, it's kind of a property that's got a lot of like junk on it, which is why they search things other than just the building. There are a lot of other places to search. While in custody, Mr. Den was interviewed by police. He said that the source of his drugs is the cities, and more particular, it's a cartel connection. He said he has someone he can contact who would tell him where to go in the cities to buy drugs. He said he buys meth kilograms at a time and splits it with other people to go sell in other places. Kilogram is 1,000 grams. He said this happened every few months. The PSI indicates that Mr. Den has 9 prior convictions. They run the gambit from defying no contact orders to receiving stolen property to drug offenses to fighting with the police, actually. Most relevant to this, and what I want the court to pay the most attention to, would be on page 9 of the PSI, where Mr. Den described his 2000 Waseca conviction involving him conspiring to import controlled substances. That's the one that sent him to prison for 10 years back in 2000. He said that in that case, he had a connection from California who would take it to the cities and he'd acquire it and break it up with other people to do with what they want. He said he'd do it every 4 months or so. He said, I wasn't dealing, but I didn't really know what they were doing, not my problem. Quite frankly, the offense Mr. Den committed here in 2024, I think it happened in 2025, sorry, 2025 is almost exactly the same as what happened in 2000. The parallels, the similarities are shocking. The foreign connection, the picking it up, the redistributing large amounts of it to other people, and then not my business what they do with it, it's the same. He got 10 years prison for that back in 2000, and he's doing it again here, the exact same thing, using foreign connections to get a drug pipeline and making himself into a fire hose of methamphetamine into the community. 1,000 grams at a time. We caught him here with 100, and the CI bought 1 gram, a mere fraction of what he described to the police. Fact is, Michael Den is a drug dealer. We know that because he's got the past conviction and the present conviction. And worse than that, what he describes as beyond that, it's really being a drug trafficker, being that middleman connection between a larger wholesaler and smaller distributors in the local community. That's his history. That's what he did here. The 10 years prisons didn't deter him. It didn't stop him. He just moved to Burnett County from Waseca instead. I think a sentence of less than 10 years initial confinement here would unduly depreciate the seriousness of this offense because of that past conviction. If we did the same punishment or less punishment for the same or similar behavior, then what message are we really sending to Mr. Den, to the community? It defies principles of proportionality. It defies McCleary-Gallion. It has to be more. That's how specific deterrence works. You ratchet up, you don't ratchet down. The repetitiveness of the facts and the offense also demonstrate to me a need for long incarceration for both incapacitation and public protection reasons. If deterrence is not going to work, if 10 years prison didn't work in 2000, then we have reason to believe that it might not work again here, no matter how much. He might come back and do it again. He still has the same connection. He could always open up shop again. He could move to a different county or just stay here and do it the same. That's why any year incarceration this court orders might save the community potentially hundreds or thousands of grams of methamphetamine coming into it. That's a lot of hurt and pain and suffering and potential death that could be stopped from coming here.
That's the sound of an American oil company.
All while Mr. Den is in custody, while he's in prison. That's the incapacitation angle. And that's time the community can be protected. I think incapacitation and public protection are really elevated in this case above the other principles we sometimes use in these cases involving controlled substances, just because of the volume and the past history. There's another reason why I think those are elevated here, and that really has to do with the defendant's overall recitation of his history when you go through in the PSI him describing his past convictions. I think there's cause to be concerned. He's not a great target of rehabilitation and specific deterrence, because when you have an offender who seemingly either can't remember much detail about their past criminal convictions that have resulted in quite a bit of jail or prison, or they recite their past criminal history as though, I had a minor role, someone else is really at fault, where there's deflection, where someone's really to blame, then you have reason to believe that the person's not susceptible to specific deterrence or rehabilitation. Those things only happen. Rehabilitation, specific deterrence only really happen when a person is affected by their own actions through guilt or consciousness or morality or the effect of the sentence itself. The 10-year sentence didn't stop the behavior here. And when you see a person recite, either don't remember or somebody else was the main one at fault, it says they don't really have a lot of insight into their own situation. If there's deflection of blame, then that's someone, we use the broader term accountability or taking responsibility. Those have certain moral implications, but beyond that, if a person doesn't think they did something wrong, if they think it was someone else, or if it affected them so little they can't even remember it, that says that something is happening inside them, that they're not effectuating behavior change either. So there's a bigger reason to be concerned about that, in that, is this going to be another case like the past ones where it's not going to affect behavioral change because someone else is responsible, or it's not going to affect them all that much because whatever reason. And we see a little bit of that even already for this case, where Mr. Den clearly tries to say the CI planted half of the drugs, and then the other half, which was an enormous amount of drugs, was still just for personal use quantity. We're talking quantities of 40, one of them was between 40 and 50, and the other was over 50, is my recollection. If the court has pause to believe that Mr. Den is likely to rehabilitate or to be specifically deterred by the sentence because of these factors. That would be more reason to, when you're balancing the different factors that it has to weigh more in the incapacitation side, more in the public protection side. And I think this is one of those cases. If a person tells you who they are, we should really be listening. And if a person tells us, you know, even after being to prison for 10 years for being involved in large methamphetamine distribution and doing it again, that I don't recall other things, or really I'm being framed by the CI, that should cause the court concern. I think Michael Den has told the court who he is.
You're saying, I mean,
I can't hear him very well. I don't
we have
know.
Here. We do have hearing devices, and we will have Olivia, she'll hook you up. And I can turn the system up a little bit without it screeching.
Thank you.
Testing. Can you hear me?
Yep.
Perfect.
Okay, so he can hear now. So Mr. Schmidt, you may continue.
Sure. I think that Michael Den has told the court who he is, both through his actions and his words. For the second time in this century, he has used foreign connections to secure large amounts of methamphetamine and distributed them into the community, if not directly by himself, by taking the large wholesale amounts and giving them to other people. He knows what they're doing with them. He knows what a person does with hundreds of grams of methamphetamine. He takes no moral responsibility for that. I noticed that when he was talking about his the California connection one, the Waseca one. I don't know what they were doing with that. Yes, he pled guilty to reduced charges, but the facts are.
Oh my God, whether you're tight on cash or not, I can.
The facts of what he did are not changed, and his history is massively aggravating. If 10 years prison wasn't enough in 2000, we should be trying 15 now. He is statutorily ineligible for CIP because of his age. I think the court should make him ineligible for the ERP entirely here because of the past 10-year conviction. I think the threat of Mr. Den does not derive from his substance abuse disorder. I think it's his connections and his ability to procure large amounts of methamphetamine, much larger than many people are able to get for himself and others. I think that for the protection of the community, the court has to act here and they have to stop Mr. Den. That should be the purpose of this sentence. First and foremost, to stop Michael Den. Second, to specifically deter him with a larger sentence than the last one he got for really the same behavior. Thank you.
Thank you. Mr. Keene?
Yes, Your Honor. When I'm just going to start with the basics. When you look at the gravity of the offense, what I think about is drug offenses tend to differ from a lot of the other ones. We look at the gravity. You know, for example, if you look at someone committing a robbery or an assault, or in worst cases, a murder, homicide, they aren't usually someone who's necessarily suffering from the same crimes, the same effect that we're trying to solve. For example, the reason we have drug laws is to stop people from using drugs on their own and harming themselves. And Mr. Den, when he talked about his past use and his use here, you know, he was a heavy personal user. And in this case, he, you know, sold a amount for the informant, you know, mainly for his own habit. And, you know, and one thing that's sort of mitigating about the offense is that generally people who look for drugs, they find them. It's not, we don't have, it's very rare that someone who, uses and or deals drugs just goes up to random people in the community. Hey, you want some meth? I mean, it's sort of the drug use element. It's sort of a self-selecting community. And I'm not saying that they're in control of their actions, because, almost no one who's in control of themselves would, choose the life of being a meth addict or heroin addict or any other drug, because you see the DACs, I see, we all see what happens when people get hooked. And it's, some people are able to casually use it, but it's a hard line and it's a pretty steep fall. Now, the main area where the DA and I disagree is about the sentencing, and I think that's because we're both looking at rehabilitation. Obviously, Mr. Dent's rehabilitative needs are fairly great because, he's battled a long period of substance addiction. He did have a period in between where he was clean. He did successfully complete a 10 years of probation. It did say revocation, but it was a 17-day revocation. It mentions that in the PSI. So it's not like he was revoked and sentenced for 9 months or 2 years, et cetera. It was, what we would normally think of more of a sanction than anything else. He was discharged from that successfully. His 2018 case, he successfully completed his 2 years of probation. He had some difficulties. It mentioned about appointments. It mentioned, bringing in materials, and Mr. Dent can talk about more when it's his time. But one of the things he's let me know is that, he was in special ed and his reading is probably on the 2nd or 3rd grade level, and that his daughter had to read some of those things for him to do it. So it wasn't like some people where they just choose not to turn things in. He has reading difficulties that make it harder for him to read and write some of those things. The other thing that's sort of unique about drug addiction is that it sort of turns our idea of specific deterrence around. Addicts have, when you're addicted, we think of deterrence as a rational thought process.
Connection successful.
If you're not functioning, suffering from addiction or some sort of mental delusion, we understand deterrence, that if you do X, you'll get Y. If you do X again, it'll be worse. When you're dealing with addiction, that thought process doesn't really apply. So I don't think the idea that, well, X deterrence didn't work, so this time we need X times 1.5 as specific deterrence really makes sense, because deterrence applies to when you're thinking straight, and when you're, suffering from an addiction, the last thing you're doing is thinking clear-headedly. Now, the other things like talk about when we're talking about rehabilitation is, some of Mr. Dent's life has changed since in some of his cases. I think when you look at the PSI, it shows that up to around 2012, for the most part, you do have, more of a personal history that involves violence. He appears to have aged out of that phase of his life. Because I know one of the things when they recommended, 8 to 12 years of, 8 to 15 initial incarceration and 4 to 5 extended supervision. one of the things they focused on was a prior history of personal violence. But if you look at his conduct since, say 2010, you can see that that conduct is, fade out of his life, especially since the last decade. And that's even factoring that, when he was arrested in 2018, he did plead to attempting to take a weapon from a law enforcement officer. But even if you include that, it's still a lower level than when he was a younger man, and violence seemed to be just, a part of life. Along with the rehabilitation we talk about that they can get, I think when you look at his daughter's letter, the letter from his ex-wife, you see something important is that there's, more of a motive. He has some motivations to pursue rehabilitation. He has reasons not to come back before the court.
I'm just interrupting you right now. I don't have a letter from an ex-wife.
Oh, PO. It should be in the exhibits.
In what exhibits? I don't get exhibits for this until it's received. And then I don't get exhibits until far after it's received in court. So if you filed it as an exhibit, I have zero access to it.
Okay, I'm just trying to,
To talk to CCAP and get that changed back, I would love it.
okay, well, I have the physical copy here of the letter from Paula Olson, if
All
that
right.
works. And
Have you seen it, Mr. Schmidt?
Oh, okay.
Yes, so you know, and I tell all of the attorneys that are in front of me now, we don't get exhibits until after you say, Your Honor, we received this, and I say received. And then once I say received, it still takes 15, 20 some odd minutes for the system to recognize and get back. So I don't usually get it until after the fact.
Okay, well, like to exhibit.
So you should know that for every other county. And if you are going to file things, even if you are going to use them as an exhibit in your hearings, I would file them as just regular old documents, and then, or proposed exhibits under a document, not under an exhibit. All right, so let me read this really quick.
Sure. No, in that case, I suppose you didn't get his blood sugar levels either.
I got that one.
Oh,
That one came through because you asked for it to be sealed and you attached it to that motion.
Sure.
When things are attached to a motion, they come through.
okay. I'll make sure.
So that's just food for thought for any other case you have in any other county.
Okay.
All right, I have reviewed the letter. I am now going to give it to the clerk. All right. Now the letter I have reviewed, and I've heard Ms. Den's character statement.
Okay, and there I'm going to refer to is just, I have 4 certificates of completion for,
If your life insurance
parenting education. I'll present them to the.
Is he taking parenting education to parent his grandkids?
Yes. I was confused by that. Yes, I was confused by that at first, because look at his age, like, well, either you're Anthony Hopkins and we just didn't know it, or, oh, we thought that someone was 81. Okay. All right. So as I was saying before bringing the exhibits, I think when you look at someone whose crimes are primarily motivated or, addiction related, I don't think that focusing heavily on the specific deterrence is necessarily useful. Now I'll deal with the proportionality. Again, we're not dealing with someone who's in a rational state of mind, not insane or anything, but just, addiction, that whole rational thought isn't there. So I don't know that proportionality necessarily makes sense. Okay. But Mr. Den, according to the PSI, did succeed on probation, even with some hiccups. And that was during COVID probation, where most of it was virtual. And I tend to have the same skepticism of virtual probation as this court tends to have about signature bonds. That, unless you can see the probationer on a fairly regular basis and see if, what services they may need, or if they're lapsing, a Zoom has its limits. But despite that, he still made it through, and he did end up having to go in once a month because with his reading difficulties, to go over things with his agent. So his agent did, within the ability of limitations of COVID, provide supervision. But those things show that, when he's monitored, and the PSI said the same thing, that when he's monitored, he tends to do better. And that, oh yeah, there it is, page 27, where it says he continues to repeat the same behaviors when there's nothing to hold him accountable. And that's on page 27. I would suggest that, there's some built-in accountability with time in jail, and I'm
Thing on page 27, because my 27 has recommended where it has sources of information.
okay.
You're talking about the PSI, correct?
Yes,
I do recall what you were
okay, then,
stating.
yeah, okay, then strike the page part
Under
of
a
it.
watchful eye, he behaves better.
Yes. But along with the coercive elements of probation to keep him on, is to try and keep him on the straight and narrow, his daughter and his ex-wife have talked about, some of the motivations to succeed on probation is that, he does have, grandchildren who need him. He does have his house that if he's sentenced for a lengthy time, will, when he gets out, he'll pretty much be a homeless man. He did show that he has successfully completed before. And it does show that, for a man who was, in younger days more violent, they both mentioned examples of where he's trying to help members of the community as well. And I'm not saying to minimize the drugs that were shared, because, we recognize that drugs, have been a scourge to the community, whether people, people take them or, hunt them down or not. But he does have more motivation than most of my clients, because he has, it was like most of my clients are right before me aren't this old. They don't tend to have the family members who rely on them, and they don't have the assistance available. And they also don't have the track record that when they are monitored, they can actually complete probation. And then when you look at his needs, so when he was arrested, his the Burnett County Jail had his blood sugar level at one of the ones, which is like a day or two after his arrest, was around 600 and something. That's dire medical attention, and it took them, 3 treatments, of heavy doses to get it to a level where it isn't, you pretty much need to go to the hospital. When he was at the time he was arrested, when he's taking all these substances, he
I swear by God, Tagidia shampoo will make you grow new hair in 2 weeks. If no new hair grows, we will compensate you $20,000. Rosemary extract is known as a DHT killer. If you use it for 2 weeks, it can quickly reverse hair loss. After 2 weeks, your hair follicles will be activated, new hair will grow, your hair will grow longer and thicker, and hair loss will stop. You can almost regain the thick hair you had when you were 20 years old. If you want to try it for yourself, please click the shopping link on the lower left. Limited time offer, buy 2, get 1 free while stocks last. Do not use this rosemary shampoo unless you have very little hair and are experiencing excessive hair loss. If you use it, your hair will grow very quickly, exceeding normal levels, and you will have long, thick hair. Your hair will be completely repaired. And we warn you that once you start using it, you will not want to stop unless you want to have thicker hair. Here is the link below on the left. Limited time offer, buy 2, get 1 free. There is not much inventory, so act fast.
Had a diabetes problem that was so severe that he lost multiple toes. And diabetes tends to aggravate or bring on depression. And he'll talk about more in his.
Just say, I'm lost in your argument.
Okay.
Honestly, way lost. I get the fact that he has diabetes, and I get the fact that his blood sugar level was skyrocketed to over 600 when he was arrested. And he lost toes because of this. But when he's arrested, and why is that a big deal? Are you indicating or informing the court that you believe that the jail did something wrong?
No, you aren't. What I'm doing is pointing out that his mental state at the time in terms of not really having much of anything to live for, and he'll talk about that more, and that now that he's had time in custody, his diabetes has been treated, and he's had time to, you know, because of the diabetes treatment, deal with some of that's lowered some of the depression issues. That's something that can be considered when looking at his future conduct versus his conduct when he was arrested. So I'm not saying, no, Burnett County Jail, because they treat him, may have saved his life.
I think they did say
Right. Now, the reason I say may is because his blood sugar was obviously high when he was arrested, still high. And, you know, I don't know how long he'd have, you know, survived before then, if it would have come down, if he hadn't been arrested that day, if he'd have taken whatever. So no, I wasn't using that to say that the jail was derelict in their treatment of him. Just pointing out that, you know, when he was arrested, he was in very poor health, and that poor health affected some of his choices that led him to sit here today.
So that's what you're saying?
Yes.
Now that he's in good health, he's going to make better choices.
He's more likely to make better choices. I don't guarantee anything, and I think anyone who does guarantee the court anything is, you know.
Yeah, it's always an error, maybe. We don't have a crystal ball.
Right, but it makes it more likely. And then he's talking about the other things that, you know, he said he's done to rehabilitate himself or make him more likely to succeed and not go down the same road if he has a lower sentence than that recommended by the state or the PSI. And I'll leave that in his own words. But I did want to point out that, you know, he's a man who is at least now looking forward to the future. He's saying, you know, I've been, you know, in essence, trying to be like not a father to my grandchildren, but I've had a parental role. So he took some of that time in jail to take some classes to help him do a better job of that. And he's, you know, taking care of his health better than it was previously. And yes, the jail's obviously directed that because they've monitored him. And, you know, if he's released when he's released at some point, whether it's now or several years from now, okay, not now, I'm not gonna ask for a release today, obviously. But when he is eventually released, you know, it's up to him to make sure that he follows up and doesn't get himself back to that physical condition that affects his mental health.
And you're bringing me back to other questions, though. He knew of this prior to even getting arrested. He knew he had health conditions. He did know that they were affecting his life and his ability to think properly. And now that they're under control, he's going to make better choices. But he could have controlled that before, went to a doctor before, and got it under control before.
Yes, Your Honor. That's sort of $1,000 question in any criminal case is, why you didn't do it yesterday.
Because he wasn't facing prison yesterday.
Well, and
Figuratively speaking,
Right.
yesterday, not literally yesterday.
right, I understand. But I mean, just in terms of, sometimes that access to service that's enforced, does help. I mean, but, all right. Right, so what I do is to point out that he does have some motivations, and the court doesn't need to do a 8 to 15-year prison sentence to ensure accountability and to ensure that.
We're Phoenix Energy, a family-owned oil.
Mr. Den has something to keep a watch over. This court has tended to use imposed in state sentences more than some of the other ones in which I practice. And, that, I'm not saying that's good or bad. In this case, it would be
Does
good.
a lot of things different than other courts in our district.
Right. And like I said, I wasn't saying that as a bad thing. And there are cases, including this one, where I think that specific accountability, or where up front what you're getting, is probably useful. And that's one of the things I'm arguing for.
You never know upfront what you're getting. A judge has discretion all the time, no matter what, even if they're recommending probation, all the time. You don't know what you're getting.
Yeah. What I meant by upfront is if he's on probation, or at some point, well, if he's on probation and there's an imposed in state, that's different than cases where you go back to the court and then the judge decides your sentence years later. That's what I was talking about, knowing up front. I was
All right.
right, because I recognize, I've talked to Mr. Den. He's aware, we're all aware that Wisconsin doesn't do the sentencing guidelines like a lot of other states, where exactly, or you almost know what's going to be in most cases. So I was talking.
In sentencing, we don't even have the other than early release programming. There's
Right.
no good time in Wisconsin for prison.
Right. He's aware that too. So that's what I was referring to, is that the where what you're getting, as I was talking about, that if you were on probation and revoked, that he would at least
Have a better idea.
have an idea that's not come back to court and hope I get lucky. It's just, you can see the size of the noose hanging over your head is probably a way to phrase it. Okay. Well, not noose, I was thinking about guillotine, but okay. All right, so.
Or you have the carrot and you do better.
Well, right. I mean, carrot stick, but fear is sometimes a better, you can call, whether it's fear or motivation, people are motivated by different things. And the carrot is that you're not going right away, as I always look at it.
Carrot is you have the ability to never go away.
Well, yeah. But, okay, but that's more of a half full, half empty glass philosophy thing, probably. All right. And the other thing I note with regards to his ability to function under supervision, even in the community, is that in the 2018 case, he did a year of home monitoring and successfully completed that, along with the probation afterwards. And the other issue when we look at it is, when we get to protection of the community, there's two ways to look at it. The DA suggested one, that if we throw him in for 15 years, we're protecting other people from Mr. Den.
His argument was actually 10 in.
I said
Oh,
15.
you said
and 5 out.
15? Oh.
No, he said 15.5. He was arguing for the
15.5.
max.
Okay, thanks. I wrote it down wrong.
Okay.
15.5.
Yeah, but the other way to protect the community is through supervision of Mr. Den, and having that deterrence hanging over his head, knowing that you, even if you're given a chance by the court to go back to helping your grandchildren and other things, you have that hanging over your head, that you could set this amount of time. And along with the actions he's taken since being in custody, specifically that he'll talk about more. He's also, as the courts were, he also had to take care of his physical property. It had a forfeiture order. And as far as Mr. Den, I know he's, through his people, he's taking care of his property. So that's something, a sign where he's showing he's trying to take care of his future and have one. And when you look at whether the people's incentives and motivations, whether they think they have hope is also a factor in whether or not they're likely to be successful versus people who feel like everything's lost and there isn't hope. And like I said, when it comes to protection of community, I think when you look at drug crimes where the person's also, is an addict, I think that one way you show that is you show that people can recover from it. It isn't just death or prison. You show that, someone can, under heavy supervision, show that they can, choose to recover and take the steps to recover on a daily basis to try and become a part of the community again. And I think the other thing that when you think about protection of community is that, drug addiction and taking drugs isn't a random thing. It's not like you're walking downtown Grantsburg and bam, all of a sudden you have meth in your hands. It's, a lot of times it's people making choices. And sometimes the difference between someone like my client, Mr. Den, and the people who tend to be informants is that the informants, got caught with a lesser amount and then chose to make a deal and collect someone else, but it's a lot of very similar behavior.
Check this out. No wires at all.
So I said, I want Mr. Den to talk about his, how he's trying to do the rehabilitation, what he's trying to do. But I think one way that the sentence could work would be for 10 years of probation. The only reason I don't say the max of 15 is because I know that empirically there's absolutely no evidence that 15 years of probation means anything. And 10 probably doesn't, but frankly, the gravity of the offense means that 5 years probably would not be appropriate. And I would suggest that a 1 year initial as a condition of that probation, 1 year of confinement in the Burnett County Jail. If he's able to work out home confinement for the rest of it, since he's been in here since January, that'd be so he can take care of his house. That would be up to jail and obviously court, and then an imposed and stayed sentence of 10 in and 5 out, because then he sees it. He understands that with his age, if he goes in, by the time he would get to see his, depending on when he got revoked, of course, but if he got revoked like halfway through it, the odds are pretty good that, the only way he'd ever see his grandkids for the rest of his life is through whatever visitation the Wisconsin state prison system would allow. But like I said, a lot of drug crime, and we know that Mr. Den wasn't, like the caricature of most people who have drugs and provide, sell them to other people. Because the caricature is that it's like, my favorite movie, Scarface, where you get the castle or the big mansion and all the women and the cars and all that stuff. But Mr. Den's house wasn't much. The video shows that, lots of it weren't in great repair. He had one bedroom that was sort of habitable, and that was about it. So I don't think we have the same issue in drug crimes with the seriousness of the offense. With the protection that we have in some of the others, because usually you can protect the public from people who are, usually users on a heavy basis. One way you protect the community is by supervision to keep them from using. Because if he doesn't use, the odds are pretty good he wouldn't go anywhere to buy. It's not like a robbery ring or something like that. He's suffering from the same things that we're trying to prevent the court from, the same problems we're trying to solve through legislation and criminalization. Mr. Den does have, a lot of things to live for. He has specific motivations to, if he's sentenced to a probation sentence with a year as a condition of as a condition of that probation, he does have a lot of things to hold over his head. He does have family, a daughter, grandchildren, even an ex-wife who was willing to write a letter. And if you'd put on my bingo card that I'd be submitting letters from an ex-wife for somebody, that probably went behind the bingo list, because usually you don't think of ex-spouses as great personal character references. But he does have those things. He also does show that he aged out of a lot of the violent conduct that the probation agent put in the PSI said was more likely to make him engage in criminal behavior in the future. And Mr. Den can, you can try protecting the community either by just purely locking them up, which is certainly an option, or it's a very expensive option, or the court can lock him up for, what we think of as that minimum amount of time needed to, establish some sort of any sort of deterrence, and with an imposed in state sentence of 10 and 5, or not, I didn't say 15 and 5 in my recommendations, just because of his age. 15 and 5 is pretty much a death sentence for most likely with his health. 10 and 5 maybe as well, but it's a couple of different ways you can do it. And I think that when you look at drug crimes where the person that's being sentenced is a serious user, I think you have to look at that different than when you look at someone whose serious crimes are assaultive, when they're theft related.
Navy SEALs are banned from doing crunches and sit-ups.
Or some of those other ones. So the defense we're asking for an imposed in state 10 in, 5 out with 1 year of confinement in the Burnett County Jail as a condition of that probation. And the terms listed by the agent and the ones that you normally impose anyway on drug cases would reasonably work. Thank you, Aaron.
So if I'm hearing your argument correctly, you're indicating that since 2010, 2013, he's aged out of the violent conduct, so it should be viewed as less serious.
I'm saying that factor that the agent put down should be less viewed, and that's even acknowledging that in 2018, one of the charges to which he pled was, the felony of trying to take a weapon from an officer. That's not, I think when you're facing an arrest, that's definitely not when you're in a rational mind for a person. And I think that's more of an aberration to how he's lived than the record shows, where the other ones where it's like, well, I had a gun with someone who stole my stuff or had issues with this person or that person. So that part I think is less of a criminogenic factor or reason than what the agent put in the report. Oh yeah, sorry. And Jörn. if the court disagrees and thinks prison is necessary, I would suggest that, the sentencing would recommend that an ERP eligibility would make more sense because of, a lot of it's use related than not having him eligible as a substance abuse. Thank you.
Thank you. All right, Mr. Den, I'm now going to turn to you. This is your opportunity to provide any statement you wish to the court. You don't have to, but it's your only time to give me anything that you think would impact or come into play with my sentencing decision. I see you have papers in front of you. Are you going to read something?
Yes.
If you're going to read something, the same thing that I said to Miss Den, please read it slowly so that my court reporter can take everything down. And if it does get emotional, you can stop and take a breath before you begin again.
I would like, whoa, that's really loud. I would like to say that other than the 2018, my drug conviction in 2000 was 25 years old. My assault and break and restraining order was in 99. And it was all over the same course of actions through a divorce and stuff. And that was over 25 years ago. I do take responsibility for having the drugs and selling to supply my habit. I don't even own a vehicle that runs at the moment. So I was making fistful of money running around. I pretty much lost the will to live. I lost my godchild. She was 8 years old. And someone ran through a four-way stop and ran her over and killed her instantly. I lost my best friend in 2024 on day before Christmas. And I lost the will to live. I had diabetes, which I've had 2 friends die from it in the same condition. The reports mental health, you can't measure one way or another. With my diabetes, you could measure it. Granted, I wasn't taking care of it. I didn't want to live no more.
What would that have done
My
to your
father
grandkids?
hung himself, and I always thought that was a cowardly way to go. If my father did not commit suicide, most likely I would. I lost the will to live. I can tell you probably 10 people in the last year and a half that's been to my place.
I don't think he heard your question, Your Honor, because he'd had to take office.
That's fine.
Okay.
He doesn't need to answer it.
Well, I'll give it a chance.
What was,
What she asked was, what do you think not having your will to live not having a will to live would have done to your grandkids if you died?
I didn't take that into consideration. I was being selfish on my own. I shut everybody out. I didn't go to Christmas in 24. I didn't go to Christmas in 25. And that whole year, I never went anywhere. And very little did I have to do with my family or anybody. If I wouldn't have got arrested when I did, I'd probably be dead by now. So no matter what happens, I'm still alive and able to talk to my grandchildren. I would like to read, I got one for the Burnett County staff. At Christmas of 2024, I was without love and the will to live anymore. I was sick. I lost my best friend on 12/24 of 23. I no longer wanted to live. I lost 2 toes. Next was my foot. I could not go out in the heat or the sun. My diabetes was out of control. I did not care. I did not want to rely on anyone to help me. January 27th of 2005, all that changed. I came to jail with diabetes. When they tested me, it was 600. And that was 4 days after I was arrested. So it was more like 800 and plus. Jail staff was scared for me and got me help, and the COs of the jail helped me every day. They the jail helped me every day. They took me to the hospital 4 times since I've been in, and every day they checked my blood sugar 4 times a day.
I found out there was a gap in our
I no longer feel that I'm going to die. Coming to jail saved me. Thank you, Burnett County Jail staff, and the help you all have done for me and saving my life. I am asking the courts to please understand and to prove to all the people that have helped me to change my life. The staff and the NA and the AA Bible study, parenting class showed me the will of God and the power to live. And, you know, I went to the hospital, doctors, okay? They said, if you don't take care of your foot, we're gonna cut your foot off. I already lost 2 toes. I wasn't going to let them cut my foot off. I couldn't do the stuff I had to do to live, and I didn't have the will to ask for help. And I'm thankful that my bail was as high as it was, so that I wasn't able to bail out, that I could focus on my problem and my addiction. And now that I'm thinking clearly, I just hope and pray that I have the chance to prove this, rather than going, if I go to prison for 5 years and get out, I got nothing. And at my age, to go try to ability to rebuild is pretty tough. I finally got Social Security 6 months prior to this. And so I have a steady income coming of $800 a month. I was on probation and home monitoring for a year with no problems at all. The only problems I had was not doing the homework assignments. And that was because I couldn't read them and didn't understand what I read. I have a 4th grade level reading.
Who helped you write your letters today?
I wrote them. And so it's the only ones I've ever wrote in my life.
Well, it sounded really good. It sounded very together.
You know, time to time, I've had God in my life, and this time God's in my life forever. I do believe that being here has changed my way of looking at life and what really is worth life. I feel I can be a positive to the community, help out younger kids in the same situation that I was 26 years ago. And, you know, you said, well, he could have got help. I could have, but I didn't want to ask, and I didn't want to live. And depression runs in my family, with my dad hanging himself as proof of that. It's not something that I just came up with and making this up. I have 2 toes that are amputated, and my foot, which I've been incarcerated for 7 months, and we take care of it continuously, and it's still not healed, which on the outside would have never taken care of it because I had no will to live. When you lose that will to live, it's just like you can't even stand yourself. You can't stand yourself to look in the mirror. You can't stand talking to people, especially loved ones, because you're not giving them the full ability of love. And I myself never reached out and asked for help. I didn't ask Burnett County to help me. They volunteered. The COs didn't have to do everything they have done. I mean, every day it's, you know.
Why did Amazon send me $20,000?
4 times a day, they have to come and see me one-on-one, and there is better life than what I was living. And who knows how much more. I'm 64 years old. I don't know how much more time I have. I know that no matter what happens, I will make it through it. It would be hard to get out in 5 years or 10 years and try to find a place to live and stuff, because I will be cut off Social Security. So I would have to sell my property anyway. And so that would be a loss. I don't want to ramble on. I just want you to know that I do have the will to live, and whatever happens, happens. I understand you have your job to do. And if you could see and give me the chance of a state imposed sentence or what time over my head, if I screw up, you're gonna know right away. I mean, I quit smoking in 2000, haven't smoked since. I quit using meth for a long time, and then I started using again. And I didn't have no income, so I made so I could use the meth to get up, to fill the wood burner, or just to get out of bed, or to just get moved. And when you'll never to explain, you know, when you said, why didn't you just go get help? It's not that easy.
I wasn't saying mental help. I was saying physical help from a doctor who can help you with your blood sugar.
That's what I'm talking about. It's hard to go there and do, and I don't understand. I understand, like, as soon as I leave, I go, you know, I don't even know what drugs I was on and stuff. And, you know, I had COVID, I was in the hospital for 18 days, you know.
I'm really easygoing and letting the defendants go, this is your time, but I'm not, I'm hearing the same things multiple times, over and over, just in slightly different words.
Okay.
And we need to wrap this up because I scheduled this for 2 hours and we only have 45 minutes left.
All right.
So I just want to make sure that you have everything, and I still see letters in front of you if you've said everything that you want me to know before I sentence.
Yeah, I think if I can ask him one question that deals with what he's talked about. Okay, you said that you were talking about rediscovering God since you've been in jail. And these are things you wrote down. So what are things that you've done as part of that journey in your life?
I've attended all the AA meetings that are possible and the NA meetings and Bible study and church. And I've met some stand-up people that gone through the same thing and that have changed their life. And, you know, nobody at 64, you don't know how much longer you have. I don't think I'm going to live to be 80, but it would be nice to know, hey, he's going to live till 80. And with that, I'll just leave it up to the courts. I appreciate everything that has happened, that I do know there's a better, sober life out there when I do get there. If I do screw up, then, you know, I'm just sitting here bullshitting you, and that's one thing I don't want.
Yeah, you really shouldn't use that language either.
No.
Okay. All right. So I've heard a lot here. I've heard a lot from you, Mr. Den. I've heard a lot from your attorney, and I've heard from the state in their argument. And I also have read this pre-sentence investigation report. I read it, I highlight it, I make notes, I do all of the things that I need to do. I've read it more than once. So
That's the sound of an American oil.
I've heard a lot from both you and your attorney that you are now a changed person. You now have this will to live, and now because you see that, you're more likely to do better, more likely to make better choices. And I do believe that that can happen with individuals. I see it a lot. I see not a lot, not as much as I'd like to see, but I do see people sitting in that chair that completely turn their life around, and then they start to do good things. But it was a slip of the tongue when I said a lot. I don't see it a lot. I see a lot of people sitting in that chair saying, I now understand I needed jail to.
Could you hold the proceeding, put it back on?
Yes.
Thank you.
All right. Can you hear me now?
Yes.
Okay. So I see people sitting in that chair who say pretty much along the same lines of the things that you told me today. I've had time to reflect in jail. I've realized the error of my ways. I'm going to do better. I have changed. I now have a better outlook for life, or I've now had the will to live. I've heard that from, I can't even count how many people. And I've also heard from a lot of people sitting in that chair, I have found Jesus. And you said, I have had God in my life from time to time. This time, God is in my life forever. You've been in custody for 7 months. You've had access to all of our great resources in Burnett County, which include a few pastors and having those services. I commend you for finding God. I commend you for having that higher power that you look up to, that you are looking to help keep you on that path. I do. And I truly hope that this is something that has now been instilled in you so deeply, it's not going to change. But again, I have people sitting in that chair who say those things, who once they're released from custody, where'd Jesus go? I can't find him. Oh, I lost him. Over and over again. Religion and belief in God and Jesus doesn't just happen in jail. You can't just be incarcerated and say, I found God. I'm going to change. I'm changing my ways. It takes a whole lot more to do that. You have to change your habits, change your associates, and completely change yourself to significantly improve your life. You can't just modify some habits, and you can't just say, I found God to have these changes. Change your habits, change your associates, and change yourself. And it's not an easy process. It's not something that people can easily do. Or we'd have so many good people, we would never have divorces, we would always have, you know, everybody doing the greatest things because they see an error in their ways. They find God and it's changed. It takes a lot of work to do that. I have you sitting in front of me today for a very serious crime.
Yes.
And I understand that in this case, with these facts, there were not any underlying violent or assaultive behaviors. It was an undercover buy with a confidential informant. It shouldn't get violent or assaultive. And then what led from that is a search on your property that yielded approximately 100 grams of methamphetamine. That's a lot of methamphetamine. That's a lot of methamphetamine. It's not just a little. That is way dealing, way selling, way being an involved drug dealer. And I do understand that you said that I've heard it, but again, I hear this a lot. I was only selling to support my habit. That's all I was doing. And all I didn't have a lot. I had a fistful of cash. I don't have a good car. I don't have a good property. So I wasn't making a lot. I was just supporting my habit. Well, you took a lot of risk. You had a lot hanging over your head to simply support your habit, when you could have made better changes. You could have done things differently, but you weren't facing a lifetime of prison. You weren't incarcerated for 7 months. Since you've been in Burnett County, I don't believe you've been incarcerated that long, except for the monitor. But then again, when you're on electronic monitor for a sentence, unless there's an attaching probation, you're not really eyes on being monitored. Not making sure that you're not using methamphetamine. It's not making sure that you're not engaging in criminal activity. We don't know what you're doing. There's not a camera in there 24/7. And I'm going to tell you, there's been quite a few people on monitor that continue to commit crimes. They know how to do it, and they think they're going to get away with it. Some do, but most get caught. So some actually do get away with it because we don't have the eyes on supervision. So we're dealing with a very serious crime. And that would be the selling and distributing of this poison drug, methamphetamine. And you've had the benefit in this deal. I am going to say this was a sweet deal. You did plead guilty to one serious crime of possession with intent greater than 10 grams, but less than 50. But you also had on your plate, and you could have been convicted of possession with intent greater than 50 grams. There was almost 100 grams or a little bit more than 100 grams. That's a lot. And there's a lot of a difference in the amount of prison time that could have been hanging over your head. So that's why I say this is a sweet deal. Because if you went to trial and if you were found guilty on all of those counts, all 5 of those counts, you faced 81 years of incarceration, 81 years, with approximately 49 of those as initial confinement. 49 of those you could have sat in prison. That's essentially your life. And it was dropped down to 25 or 20 or 25. It was 25. So a possible 15 years of initial confinement as the max, 10 years of extended supervision as the supervision piece, which could later be served in prison. But it dropped from 81 years over your head to 25. That is a sweet deal. So I look at the seriousness of the offense. I have to look at your character as well, and also that need to protect the public. And so bringing in all of those, I have to look here with having very different recommendations. I have one from the state, 15 in, 5 out. I have one from Department of Corrections, 8 to 15 in, 4 to 5 out. And I have a recommendation from your counsel of 10 years of probation, 1 year of conditional jail with an imposed and stayed sentence of 10 years in, 5 years out. They're all different. But we know here, or we should know, I know there was an argument for your attorney for probation, but here for the sentencing, with 100 grams of methamphetamine, 100 grams, even though you pled to 10 or 50, no more than 50, that's what you pled to. But in the facts, in the evidence, there was approximately 100 grams of methamphetamine. It's not a given prison sentence, but prison must be contemplated. So the dispute here is, what should the court do with sentencing? And your attorney would like me to look at probation. Consider probation first. A court considers probation first unless confinement is necessary to protect the public from further criminal activity from you, okay? Or you, the defendant, you need some kind of correctional treatment. You haven't taken it upon yourself to get the treatment yourself while you were in the public. And so you've been forced to get it. You will get it if you're in an institution, a correctional facility. You said today, exactly, jail saved your life. But for the fact I was incarcerated, I wouldn't have got my health under control. I wouldn't have regained my desire to live, all of those things. I also have to look at probation. Unless probation would unduly depreciate the seriousness of the offense. Unduly depreciate the seriousness of the offense. So you have to look at this offense and you have to determine, how serious is this? Are we dealing with 1 to 3 grams of methamphetamine or residue in a pipe? or are we dealing with 100 grams of methamphetamine? This is serious. This is a very serious crime. And at the plea, the court went over that dismissed and read-ins can be used against you for sentencing. You can't be sentenced above the maximum penalty. But all of those dismissed and read-in counts come into play. And the court looks at those. I understand and I hear you and I believe that you used substances. You used methamphetamine.
Connection successful.
I need to determine, are you simply a user or are you a criminal? That means a user who sells, a user who engages in other criminal activity, burglary, anything else. What is it? You claim that you're simply a user, but for the circumstances, you needed to have more money in order to support your habit. You weren't making enough on Social Security. But then again, we have 100 grams of methamphetamine. This one time in life where law enforcement went and they went kaboom and they picked one point in time and they found 100 grams. Statistics would show and theories would say, this isn't the only time you've had 100 grams of methamphetamine. This is the time you got caught. And you got caught because of a confidential informant, and that's sale. And if I'm reading the PSI correctly, you're not accepting the responsibility. I've heard a little bit of accepting responsibility today from your attorney and yourself. But in the PSI, when all of this information was brought in, I didn't hear any acceptance of responsibility, any accountability. It was passing the blame, passing the buck to somebody else. Because you stated that the reason you had all of that methamphetamine is because you allowed someone to stay at your property, and when you kicked that person out, the methamphetamine was just left there. So you're trying to have the court believe that whoever was staying at your house had the methamphetamine and you kicked him out and oops, the meth stayed, oops, you got caught. And if I'm recalling correctly, the alleged CI is the alleged person you kicked out. Why would the CI go and buy methamphetamine from you if it was his methamphetamine? That makes sense. It just doesn't make sense. You did claim ownership of 56 grams of methamphetamine located in one of the vehicles, but you claimed it was only for personal use. You never sold methamphetamine to anyone. That's what you said. I read it. I read it multiple times.
I'm sorry.
You lied.
Okay,
So you don't get to talk now. I do.
sorry.
But I hear today the complete opposite of what's stated in here and the alleged facts in the criminal complaint. You're passing the blame to somebody else. Wasn't my meth, but I was going to sell that meth back to the person who left it. That makes sense. It just doesn't. And claiming ownership of over 50 grams of methamphetamine for personal use also doesn't make sense. A big part of the court in sentencing is looking for remorse, looking for real positive change, looking for someone who is going to be open and honest, albeit not tell every single fact, but about the crimes. But here, you did not accept the responsibility. You just had excuse upon excuse and reasons for damaging our community, for being a part of a destruction of our community. This is the community where your daughter lives, where your grandkids live, where perhaps you have friends here and they live. This is the community where your central family friend connection, they reside. And you're a part of destroying that.
Yes.
So the court has to determine, does this sentence rise to a maximum possible penalty? It might.
Yes.
You're saying yes, it does?
I was out of control. I was not.
I would just, okay, because you're saying that I should sentence you to the maximum penalty.
Yeah, I think when he said yes, he was just talking about yes, and he understood that that was your thought process versus saying, you know, because I can tell you I've talked with
Maybe
these.
he should zip it.
Yeah,
My time to talk. I went on and I heard for over an hour from your attorney's argument and your argument. I've heard it from both of you, but now it's my time to talk. This could be the maximum possible penalty, or it could be looked at as something a little bit lesser.
I thought I'd done everything right with our money.
What the court has to look at here, and I'm focusing on as well, is your character and your rehabilitative prospects and the need to protect the public. You do have a criminal history, a lengthy criminal history, one that involves a crime very similar to this, albeit from 2010, but very similar fact pattern, very similar connections. You have connections with the cartel, at least one cartel, maybe more. I'm not sure. To me, that's telling me that this is more serious though, and it could involve violence because I've not heard of the cartel giving out flowers and candy when they're not getting what they think they deserve. Violence, guns, deaths, a lot of assaults, substantial batteries, a lot of those things happen around cartel activity. Again, not a circus, not a party. So just because this didn't involve violence, again, because you were taken out of that brief little part of the timeline, doesn't mean that there hasn't been or couldn't be violence associated with your actions and your crime. So in needing to protect the public, I have to look at if there are victims. We don't really have real victims here, not victims of substance, but we have the community as a whole, the people that live here, the people who have been impacted by your criminal conduct, including the people you have sold methamphetamine to and their families, because they have all suffered. They have all been harmed. They have all been affected in some tangential way. And that includes your grandkids. They've been victims here too. Your daughter, she loves you. I have seen her in here multiple times supporting you. I'm gonna guess she doesn't love what you've done or love some of the things you've done, but she unconditionally loves you. But she has been a victim too. So as your son, who is now sitting in prison in Minnesota, he is a victim too. And you've been doing this since you were young, early 20s, early 30s. Pretty much Ms. Den's whole life. I have not seen her in here, and I praise her for that. She is leading a good life, and she is raising her kids to the best of her ability. She has a strong will. So she has not followed your path. which is good. So I have to look at other things in protecting the public, such as what Mr. Schmidt has said, specific deterrence to specifically deter you from engaging in this type of activity and crime, general deterrence to say, hey, public, hey, people who want to do this, I think you should think about this again. Take a second thought, because I don't know if you want to have this potential consequence, this potential crime. In sentencing an individual, I am told to give confinement an amount that is consistent with those things, protecting the public, the gravity of the offense, and your rehabilitative needs. Those are what I need to focus on. And here, it's hard not to see the harm and the seriousness, and it's hard not to see the level of criminal thinking and criminal involvement when this was an undercover sale. So how many times did you actually participate and engage in this destruction, selling of this drug? Most likely multiple times throughout your time, multiple times, at least around 2018. And other than that, I can't be for certain. I don't have evidence of that. But a lot of times, because you got to know, crime happens everywhere. We just don't see it. And people just don't get caught. It shows a lot of criminal thinking. And I commend you for having a heart. I see that you do have a good heart. And I've seen that, and I've seen how you've acted towards your son. Is his name Josh? Josh. And you've acted towards Ms. Den, and how I hear how you are with your grandchildren. I see that. Good people can have bad qualities and make bad choices in their behavior.
If you're sitting around Googling how to make money on the internet and you're
You have helped, as your daughter said, an elderly woman to make sure she has all of her things, even though you don't have money. Did she have food? Does she have a ride? Does she have a place to live? All of those things. I do see the good qualities that you have. But so far, the good qualities have not outweighed the seriousness of the criminal offense. Because again, I have to say, our county, our community is being destroyed. Families are being destroyed. And here you are not just a user, you are an addict. You are part of this and being a devil of the destruction. I see changes from the time you were arrested, and I hope those changes and that rehabilitative steps and your cognitive thinking, I hope that that continues to change and to solidify, and that you want to be a contributing member of society and the community. You want to be the grandfather and the father that you weren't at all times. You want to be there and be present. I see that. Hopefully that'll stick and stay. And I did hear your medical issues, and I do take that into account. And I did hear about your now having a will to live where before you didn't, so it just didn't matter. I do take those things into account. But they're not necessarily reasons not to send you to prison. Those are reasons to show, look at, I am changing. things can happen. I now see a brighter future. So in sentencing, again, the seriousness of the crime and the need to protect the public outweighs the character, well, outweighs the rehabilitative prospects. Because this is very serious. So with regards to count 5, possession with intent, amphetamine, methamphetamine, greater than 10 grams but less than 50. I am sentencing you to 12.5 years of initial confinement and 8 years of extended supervision. And that is imposed immediately. This is too serious and too much of a need to protect the public that can't be overlooked. And a sentence less than this would unduly depreciate the seriousness of the offense. I am not making you eligible for early release programming. If you were a straight user, definitely. This took a lot of intent, a lot of planning, a lot of dealing, a lot of figuring out who your contact should be in the cartel. That it's not simply because you're a user, you are a criminal. And the fact that you used just means that you made that choice. You made the choice. A bad choice, but you made that choice. And you made the choice to use methamphetamine with knowing the effects of methamphetamine and how addictive it is. You made an informed decision. You also made an informed decision when you decided to sell and engage in delivery of methamphetamine. As conditions, absolute sobriety, no use or possession of any illegal drugs, substances, or paraphernalia, criminal thinking or thinking for a change or breaking barriers, one of those programs. You must follow the rules of supervision, regular drug testing, no contact with anyone who is on felony drug-related probation or extended supervision without approval of your agent. Absolute sobriety, no alcohol. I'm ordering you to provide your DNA. The jail will make sure that they take that. I don't believe this is one where it can be expunged. $518 in fines and fees as it relates to the felony. Jail credit.
196 days, Your Honor.
196 days of jail credit, no use or possession of an illegal drug, or no use or possession of a firearm for life, no voting in any election until your civil rights are restored. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. If you fail to pay your fines and fees, not only will the court enter a civil judgment against you, but you will also be subject to a warrant and a potential of 6 months more of incarceration. Again, if I did anything lesser, it would unduly depreciate the seriousness of the crime as well as the need to protect the public. Mr. Schmidt, anything that I'm missing?
Not for me.
Mr. Keen?
No, Your Honor.
All right, then we are adjourned. Thank you.
12 and a half. Right, no ERP.
Well, that's it for today, everybody. I broadcast every day at 3 o'clock p.m. Central Time, 4 o'clock Eastern Time. Again, if you like this court content and you're not a subscriber to this channel, please do me a big, huge favor and subscribe to this channel and help this channel grow. So that's it for today. Ciao, ciao, and ta ta. I'll see you again tomorrow. You all have a good evening.